Good day, everyone. Good day, everyone. My name is Monica Tabengwa. I am the policy specialist with UNDP based in South Africa. Welcome to our webinar on South-South learning for LGBTI persons, activists, and human rights leaders and allies from challenging country environments. I'm going to give just a brief background why we are here and why we thought this would be useful. So in 2022, Human Rights Campaign and UNDP's We Belong Africa started discussing how to best support LGBTI civil society organizations and key allies working in challenging and criminalized environments in sub-Saharan Africa who are seeking to develop effective strategies for countering growing anti-LGBTI sentiment and actions across the continent. Given the many internal and external challenges they face, we brought together these activities and key allies, especially those who have experienced similar challenges, to share some ideas and strategies and learn from each other. Some of the recommendations from the workshop included the need to continuously share lessons and insights across the region and find new solutions to address the situation. So this webinar came about because of that, and it will provide a platform for dialogue with selected speakers from these challenging environments to share outcomes and lessons learned, talk about challenges and opportunities to strengthen LGBTI+ capacities for scaling up the response, as well as give an opportunity for insights on countering the challenges in their own countries. So we have 4 speakers from Uganda, Kenya, and Nigeria, who will be giving us their own experiences on how they have reacted and how what strategies they have and what some of the recommendations from the workshops were. So the webinar will be run this way. First, we have 2 speakers from Uganda, which is Adrian Juko and Richard Lusimbo. And then we will be followed, and then we have a speaker from Kenya, which is Njeri Gateru, and then a speaker from Nigeria, Hilary Ogbonna. Just a few logistics. They are participants of the audience. You can make comments using the Q&A session. You can also write your chat through the chat section. You can also make your contributions. And we will try as much as possible to incorporate these contributions into the presentations by each of the speakers. Each speaker will have 8 minutes to speak, and then we'll take a break and look at the questions, and then come back and give them more questions to address some of the questions and maybe give some other recommendations. And hopefully we'll be able to give enough insights and information for an interactive discussion. I'm going to start with Dr. Adrian Juko. Dr. Adrian Juko is a Ugandan human rights lawyer, researcher, and activist. He is the founder and director of Human Rights Awareness and Promotion Forum, an organization that operates a specialized legal aid clinic for LGBTI persons and other marginalized groups, and advocates for legal change in Uganda. He's also the chair of the legal committee for the Convening for Equality, which is currently coordinating the legal efforts to challenge Uganda's anti-homosexuality bill, or now Act of 2023. A role that he also played during the nullification of the 2013 version of the bill. Adrian holds an LLD from University of Pretoria. Now, Adrian, you have been involved in litigation strategies for many years in Uganda. Can you just discuss, in the 8 minutes allocated to you, give us a broad context of the realities, opportunities, and challenges, and how you have used litigation strategies to amplify the lived experiences of LGBTI persons in Uganda?
Thank you so much, Monica, and
yes.
Well, good morning, good evening, good afternoon, colleagues and persons on the call. The discussion I think that we are holding right now is important, more especially critically for us in Uganda at the moment. As most of you know, Uganda is currently facing anti-LGBTI Act, which has now become law in Uganda and is in force, essentially, meaning that people can be arrested for what the law terms homosexuality. So homosexuality is no longer sexual orientation in my country. It's now a criminal offense. People can be arrested for aggravated homosexuality. So homosexuality is imprisonment, and then aggravated homosexuality, which is essentially repeat offenders, sex with someone with a disability, that carries the death penalty at the moment. So the law also criminalizes promotion of homosexuality, which is essentially what I'm doing right now, because the law uses the term normalization of homosexuality. So right now, if you talk about homosexuality, an issue that can be talked about, then you are basically doing what they call normalization. So if you publish, if you search, if you, I guess even if you litigate, so shall see how they interpret this, that even if you go to court, or if you call movements together to build a movement around litigation around LGBT rights, you are doing what they call promotion of homosexuality. And as professionals, we have an obligation to report someone that you know is basically engaged in homosexuality. So this is quite tough, and that attracts 20 years imprisonment, or a fine of $1 billion shillings, which is quite a lot of money also in Uganda shillings, if you are an organization. So with this kind of involvement, one of the avenues that we have is certainly litigation, because we've tried all that. We tried engaging the executive before the law passed. We tried to engage in parliament. We tried to engage in the executive. We now have to engage the judiciary, because at times litigation becomes the only avenue that you have left for you in case you are marginalized and you cannot access the usual channels effectively as other people do. So I think that's the allure, that's the attraction that litigation has most of the times, that courts of law cannot refuse to hear a case. So they are the only organ of the state that essentially can't turn you away. Parliament will say, hey, we don't want your views, and they may kick you out. The executive may not see you at all, but the judiciary is the only organ that cannot say go away. So regardless of their views on homosexuality, they have to hear our petition. They have to decide it. So so far, 2 petitions that we filed under the Convening for Equality, which I'm sure Richard will give more context about and how it operates. And one, basically, they both essentially challenge the law on procedural grounds and also substantive grounds. So we're trying to use procedure as much as possible, because it was procedure before that got rid of the Anti-Homosexuality Act at 2014. But also, if that fails, we have the aspect of substance, like some of the provisions of the law, including provisions criminalizing consensual same-sex relations, provisions criminalizing promotion of homosexuality, are essentially as against the Constitution of the Republic of Uganda. And in terms of organizing, the cases just didn't come to be. The cases have been planned. We knew all along that we had to go to court, is essentially if the law became law. And that's why on the very first day that the president signed that act into law, we went to court, because we knew this was coming all along. So the litigation that we're doing is planned litigation, and that's the kind of litigation we try to do in Uganda. With colleagues, discuss the cases, how they impact, even anticipate and who is on the panel, analyze who is on the panel, what are their kind of views, and then decide to go to court at that stage. So for me, one of the things I want to highlight is that the litigation that we're doing right now is litigation that has been planned law. litigation, this is not the first time we're doing litigation in Uganda, and also it's not the first time that we are planning litigation. We've done quite a number of cases, more than actually, if you count all the cases that we've done over the past 4 years. We've brought a number of cases to court, many of them, half of victories, the other half has not resulted into victory. But even those that have not resulted into victory are planned in such a way that you, even if you lose, you don't lose it. The cases can be, it's about the individual case. It can also be about an issue that's brought in a narrow way so that it doesn't affect how rights of every other single person. So we have one of the cases that we have is one that was about the right to liberty and the right to a fair hearing during the context of COVID-19, where we clearly said that, you know what, if you cannot deny LGBTI people access to lawyers just because of their sexual orientation. And the court agreed with us and said, well, you can't have people in prison who cannot access their lawyers just because they're LGBTI. Of course, the court didn't exactly put it in that way, and that's also another way. That when we brought this matter before court, sometimes we leave out the LGBT component, although it's the elephant in the room. Sometimes you leave it out because sometimes if you bring it in, it causes issues with the judges, and this is something we need to discuss. Sometimes the judges are like, hey, and then they become hostile. But then other times, they actually hear LGBTI cases with LGBTI components in there, and then they give you good judgments. I think we've observed a trend that from about 2014, cases that have LGBT clearly spelled out usually are lost in the courts of law. And cases that don't have LGBT but concern LGBT are actually won. Because I think then the judgments are less clouded by these feelings around litigation. So for me, litigation is important, but it's not a silver bullet. It's not the kind of thing that we have to always. And first of all, there's an like, how do you what society feels about LGBTI persons? Litigation can do that for you, but not exactly. Litigation is not a substitute for movement building. Litigation is not a substitute for ensuring that we have lawmakers, plus the target executive, plus the target the general public in terms of their views on LGBT rights. So litigation for me is a last resort, like we're doing it right now, because we've explored all the other options, and litigation seems to be the option that we have now. And you cannot just let us wear litigation alone, because this is what's going to deliver us to the promised land. No. But at the same time, for issues like this, the judiciary comes in handy. They can't chase you away, but also they have the duty to interpret the Constitution and make sure that the Constitution, that the laws that are made in the country do for the Constitution. So in conclusion, this calls for elaborate planning. Do not just go to court because there's a courtroom. You go to court because you've planned and you've worked with the best strategy to go to court. And more especially, never leave your clients behind. For us lawyers, sometimes we get, we go on a frolic of our own, and you leave your clients behind. Always have your clients with you. Let them understand what this is about, how it's going to be, and how it's going to impact them. So for me, litigation for LGBT rights should be litigation with LGBTI people in the room as part of the conversations, as part of every step taken, and as part of the cases themselves. Thank you so much, Monica.
Thank you, Adrian. I like what you said when you said that, you know, the lawyers cannot turn you away. They cannot refuse you, which basically means the objective is not necessarily that you are going out there just to win. It's a bigger strategy around movement building, as you mentioned, and making sure that information, the correct information, is out there with the people, all the clients as the litigants, and your other more general clients and the LGBTI persons in the country, as well as their allies and other people. So we are going to move on to another person in the neighboring Kenya, which is Njeri. Njeri identifies as a queer feminist human rights lawyer with over a decade of experience working on protection of minorities in Kenya, including asylum seekers, internally displaced persons, and LGBTI communities. She is the executive director of the National Gay and Lesbian Human Rights Commission in Kenya, which is an organization that provides legal aid and engages in strategic litigation towards equal rights and protection of LGBTIQ persons in Kenya. They have successfully litigated for registration of LGBT organizations and the ending of forced anal examinations. Njeri, I would like you to address the similar questions to Adrian. More specifically, just give us a brief and broad environment, what the framework in Kenya is like, and how you have used litigation as a strategy to get the objective of your organization, which is to get equality for and equal protection for LGBTI persons in Kenya.
Thank you, Monica. So Kenya, like a lot of our countries, is a former colony of Britain, and so we basically have a similar legal system to that of Uganda, Nigeria, and a number of our colleagues on this call. So we do have laws currently that criminalize homosexuality, making it punishable with up to 14 years imprisonment. And with this, we're speaking specifically about same-sex sexual conduct. And there's other penalties for specific crimes, such as indecent acts between adults, which could be anything from people of the same sex holding hands or kissing or, harassing each other or whatever. It's largely up to the discretion of the judges or the magistrates before whom the matter appears. So we, as the Kenyan movement, have been engaging in litigation for quite a while. NIGLHAC, the organization that I work for specifically, has been engaging in strategic litigation for the last 10 years. And part of the reason why we began the work of engaging the courts was that we realized that we're existing in a space where there had been a lot of erasure of the lives and the identities of queer people, and not erasure in a way that's harmless, is that in the ways that we were erased, then crimes against people on grounds of their sexuality, on grounds of their gender identity, on grounds of their sex characteristics were not being recorded, were not being addressed. There was possibly no access to justice for people like us. There was no redress, basically, for anyone who had been harmed in any way or discriminated against in any way on grounds of their sexuality or gender identity. And what that created was a system of deniability for government and for states, and particularly institutions that have the mandate to protect people like us. So we would go to court or would present an issue and say, look, members of this community are being violated, and the government will be like, but where is the evidence? What do you have to show that this is actually happening? So I think at some point we all get to a point of tiredness and decide that we must engage our judiciary. It feels like the judiciary is the only backstop that we have, in that we had been denied by all other branches of government, really, and all of the systems and institutions that are put in place to protect people. So we have been litigating since 2013, beginning with asking court to register organizations, LGBTIQ organizations, which is a case that has been ongoing, that had gone on for 10 years. Earlier this year, we received our ruling from the Supreme Court that basically affirmed the decisions of the lower court, basically saying that we are within our rights to register and we should be registered as an NGO in Kenya, which began a long series of madness, if I could quantify it as that, and a lot of backlash and hyperbolic homophobias within the country. What's interesting to me at this point is that, and I want to bounce off of what Adrian was talking about, is that Kenya has proved itself quite progressive in the ways that courts interpret the constitution in as much as it applies to persons of a diverse gender, sexuality, identities, right? Out of 6 decisions we've received from the courts, starting from the High Court to the Supreme Court, 4 have been successful. We've won 4 cases in up between these 3 higher courts, the High Court, the Court of Appeal, and Supreme Court, and we've lost 2. And in the 2 that we've lost, 1 is currently under appeal, and the other one that we've lost, we won at appeal. So we have quite an impressive track record of litigating on matters, on LGBTQ matters, which I think is quite impressive, given that we exist in a place where there has been so many questions about the independence of the judiciary, the willingness of parliamentarians to engage on these matters, the willingness of the government to engage on these matters. But so we're now sitting at a very weird spot on the we're on the fork, we're a fork on the road, where last year we had a change of administration, and we quite quickly saw a change of dynamics in the ways that this country has operated, particularly within the ambit of constitutionality. It seems more every day that we're becoming a church state rather than a democracy, rather than existing within and under the rule of law. It appears quite so often that matters of religion and matters of state are conflated. And of course, this has repercussions on communities like ours. We saw at the point in February where we received this really fundamental judgment that basically says that, in no uncertain terms, this ruling says that sexuality, sexual orientation is protected from discrimination per the Kenyan constitution, which is a huge thing. It's a massive, massive undertaking to have a court pronounce this, and to have a state and quite a bit of a homophobic state have this in record from the highest court of the land, right? And so immediately what we saw was a very coordinated, but then very led from a religious standpoint, reprisals against this decision, and basically dissatisfaction in the ways that people have perceived progress by people like us, progress by LGBTQ folks. Even at the point that we're receiving this ruling, the public conversation was very quickly shifted to a religious conversation, a morality conversation, a cultural conversation, all of which was tied up with a big, homophobic, transphobic bow. And on top of that, we now have an anti-homosexuality bill draft that we've been threatened with over and over again. And I think we're now at the 4th version of it that markets itself as a family protection bill, but has absolutely nothing in the ways of protecting family. What it has is steep penalties for people who love people of the same gender, for people who express their truths, for organizations who advocate for people who identify as LGBTQ, for organizations and institutions that provide services for these communities, and just really new, and I mean new in Kenya, new in our context, but a very Amerocentric view on gender. And we have like random stuff on these bills, like penalties for people using bathrooms of a different gender, penalties for people using they as a pronoun, penalties for people who organize sports, and if those sports are gendered. Well, that for people who organize sporting events, and that within those sporting events, they should be gendered, and that anyone of a different gender who's allowed to participate in a different gender sport, then there are penalties for that, which are like just absolutely random, seemingly misplaced, like do not read the room type of legislation. So what then it does is highlight for us very clearly where the intentions, where the motivations for creating these kinds of punitive discriminatory laws comes from. And it really quite clearly links our struggles with an exploitation of hatred from different countries and the reception of that by governments and people who are elected to serve and to protect us. Yeah, so that would be my introduction to this.
Thank you, Jerry, for giving us that introduction. And I think you have echoed the same sentiment as Adrian, pointing to that it took a long time for this to happen. There was many players, and the issues were intermingled with culture, traditional norms. So it takes quite a lot of time and effort, and a very nuanced and well-planned effort. And it cannot be done by one person. It has to be done by many, working together to ensure that this at least, you address not just the legal issues, but all of the other social and political issues as well. Which takes us nicely into the next presenter, who will be talking about coalition building and collaborations, which is Richard Lusimbo. And Richard Lusimbo is from Uganda. He's a renowned human rights activist, health service authority, and a prominent figure in the LGBTI community. He is celebrated for his role as the founder and director of the Uganda Key Population Consortium, a coalition that amalgamates key population organizations and networks to address pressing issues such as the diminishing civic space and the dwindling resources for key population-focused programming in Uganda. Richard is also the co-founder and board chair of the Global Black Gay Men Connect, and he also serves as a co-convener for the Convening for Equality, a coalition of LGBTQ individuals and organizations, allies and partners opposing Uganda's recently enacted Anti-Homosexuality Act of 2023. Richard, Adrian has given us an introduction into the environment of Uganda, but from your point of view, can you share some of your experience and insights relating to building effective and progressive coalitions to resist, counter, and respond to anti-LGBTI legislation and actions? Please.
Thank you so much, Monica, for that elaborate introduction. But also thanks, Jerry and Adrian, for giving us the perspective when it comes to the legal space and challenges and our wins and what remains in that same arena that we continue to fight. Specifically, when it comes to coalition building and in our spaces as LGBT activists, as activists who are passionate around the rights of LGBT, it's been very important to have one common ground, because the forces that we are fighting are well coordinated, are well supported, and for us to win, we need to work together. In Uganda particularly, we have always found grounds of working together as a way of response to anti-LGBT legislation or any policies that come take out the rights. But not only that, but we also look broadly at other vulnerable communities. And what's happening in Uganda right now, we've gone through it before, almost 10 years ago, when we had the law that was passed in 2013 and signed into law by the president in 2014. But before that, the bill then was first tabled in 2009. And immediately that bill was tabled, Civil Society Coalition, Human Constitutional Law Coalition was put together, and that coalition had LGBT and other groups, human rights groups, women groups, feminist groups that were really passionate and all came together to work on challenging the act. And indeed, the efforts of the coalition brought everyone together, and there were forces rallying to fight the bill, even when eventually it was passed by Parliament and signed into an act. And of course, we know that in 2014, August, the Constitutional Court did nullify the law, as Adrian ably explained, but these were efforts of communities coming together to work for a common good, and that's how even the challenge was put and presented in the court, and we won. What this means is that it's really important, regardless of the situation we're going through, collective voices are very important, and this is something that we have seen in Uganda, that through this collective voice, we're able to have as many hands to do the works that may need. This is why now it brings me to recently, when the conversations around the anti-homosexuality bill were coming and developing, we quickly and also been reading and looking at the situation. For example, the closure of SMAG and suspending its activities last year in August. And then we saw an increase in terms of anti-gender sentiments and the movements growing in the country. And of course, you all know there was a time when there was a leaked report from the NGO Bureau that was looking at closure of different organizations like mine and that of Adrian and many others. And because of all this, we also looked at the attack on the SRHR in its broadness. So we came together again as a community, and through this, we're able to again say we need to have a common ground to rebuttal all these sentiments that are growing, that could even eventually grow into having legislations brought in Parliament and discussed. And so in February, we're able to come together, and we formed the Convening for Equality. It's a coalition that brings together LGBT, human rights, legal, and SRHR organizations together to really work on this jointly. And this is why we have, for example, the legal committee that is co-chaired by Adrian and another colleague from Chapter 4, Anthony, and other committees that different partners and communities are leading the way in the response for this. What we've seen with this kind of organizing is that having a collective voice is very important in a way that it makes it much easier for coordination, but also how partners are able to support, but also know what's happening, but also the solidarity and the message that it's just not an individual or an organizational responsibility, but rather it's now a collective responsibility for all communities. And this also helps to create space for resource mobilization, because we are all diverse and we're all interlinked and connected differently. But also because of that, then you're able to tap into the different sources of funding, the expertise that comes from the different angles. And we've seen that this has really helped us. And as Adrian said, when we knew that the president had indeed signed the law, we filed on the same day. And now as CFE, we have 2 petitions that we're supporting. There's also a 3rd one, but this shows the power of working as a collective. And I think this is something that we've seen and we continue to enjoy and benefit from as a community in Uganda. And through the collectiveness, we are seeing a lot of change and unity among the community and the partnership and the allyship. So I really felt like I should share this. And so thanks so much, Monica, for posing that question. Thanks.
Thank you very much, Richard. I think we have all appreciated Uganda's organizing and showing others, other countries facing similar circumstances, how having a strong coalition working together and that you can call on, very quickly is very good in terms of being able to respond timeously and strategically to some of these challenges. And I think just for morale building, it's good to know that you have others behind you, with you, working with you. Thank you for sharing that. Nigeria went through a similar process right about the time when Uganda was going through the first bill. And in the end, the act, the Same-Sex Prohibition Act was passed. So they went through a lot. And we have someone who's working for the government, or rather working for the National Human Rights Institute, who can share with us. And we have here with us Hilary Ogbonna. He's a senior human rights advisor with the National Human Rights Commission in Nigeria. He leads the program development, coordination, and partnerships, including the protection of the rights of sexual minorities using various mechanisms. Welcome, Hilary. So, similar to the others, spend a few minutes telling us just about the context, the realities, just the broad strokes around the environment in Nigeria. And then you can continue on and tell us how, as a National Human Rights Institute, how do you engage your government, recognizing that even in hostile environments or in contexts that lack supportive allies, they can be entry points into creating positive policy change and building successful advocacy campaigns. Thank you.
Thank you very much, Monica. And I want to also thank the participants for coming and also my co-panelists. I want to start, of course, by expressing our utmost solidarity with our friends and colleagues in Uganda, and also to state that we are solidly behind you, and also we'll do all within our powers and within our reach to ensure that human rights are protected, not just in Uganda, but all over the continent. I bring you greetings from the National Human Rights Commission. Monica was right. I work for the government, and that's actually the very complicated aspect of what we do as a Human Rights Commission, as an independent organ that is government. We have seen ourselves also operating in almost similar environment with what Uganda is having, and we didn't shy away from our responsibilities. At the moment, we have the Same-Sex Marriage Prohibition Act, which is almost 10 years old now. And but prior to that, we had the Sharia laws of states, Sharia laws in more than 10 states across Nigeria. So why the Same-Sex Marriage Prohibition Act makes provision for jail terms of 14 years, of 7 years, and thereabout. The Sharia laws of states didn't do that. Rather, the Sharia laws of states provides for maximum death penalty by stoning or by hanging. And so that is the extreme cases that we have. Unfortunately, we've not had any conviction as of today under the Same-Sex Marriage Prohibition Act, but we've been having convictions under the extreme laws of Sharia, and this is where the Commission has been working on. And but even though we have not had any conviction under the Same-Sex Marriage Prohibition Act, its existence alone has led to quite a number of institutional discrimination and also biases against people in the community, as well as social bias and discrimination by the rest of the population. So in terms of institutional biases and treatment, you have law enforcement as number one violators. You also have institutional bodies like ministries that provide services. For example, we have a case before us now of someone who wants a passport, but the Nigerian immigration has refused to recognize gender, and this has been brought to our attention recently, and we are working on that. And then there is also the issue of access to social services, access to education, access to healthcare, and people in the community are heavily discriminated when it comes to that. But let me just take a little bit back and talk about our work around strategic litigation. And I want to agree with other speakers, both Andrian and Jerry, that strategic litigation is very, very key. When and how you deploy it is dependent on the context of the country. In Nigeria, we are doing everything at the same time. We are putting everything forward because you really don't know which would work out. And when I say everything, we are looking at strategic impact litigation. We are looking at legal aid. We are looking at advocacy to the government. We are also looking at law enforcement reform, all at the same time, because it's a complex country. The size and also the institutional complexities in Nigeria, the fact that you have state governments, you have the federal government. Some state governments are almost as big in terms of mandates and construction like countries. So you need to address some of these complexities. In Bauchi State, the commission took on appeal a conviction of three individuals that were convicted for sodomy under the Sharia law. They were not only convicted, there were no defense for them, and they were just handed into jail. And by the time we knew about it, they had already been convicted. But we've taken the appeal, and the appeal has concluded. And this is the commission instituting the appeal in its name. Then the commission has also been part of strategic litigation on declaring the Same-Sex Marriage Prohibition Act as unconstitutional. And this we have done in 15 cases before the Federal High Court in Nigeria. And in all of the 15 cases, we were successful, the commission and its partners. And the Federal High Court has declared certain sections of the act as unconstitutional, and in terms of the fundamental rights provision of the Constitution. So, for instance, it may be criminal in Uganda to have this meeting, but in Nigeria, no more, because that part of the act has been quashed by the Federal High Court. These judgments need to be popularized so that people in the community also are aware that we have different courts, 15 of them in separate judgments have nullified those particular portions. There are still portions that it didn't nullify. The marriage between same sexes have not been nullified. We are still working on that. And then finally, I also would want to talk about the social care and also the post-legal work that the Commission is trying to do for members of the community, including resettlement, including also assisting them to continue living and having access to socioeconomic opportunities. These are not covered naturally by our mandate. So we are working with other people who have the mandate to deliver on this kind of programs to support persons, for instance, whom we have conducted successfully their cases, as we are hoping would happen with the Bauchi case. We are also working at having a coalition of government partners that are working around issues of human rights and human dignity. for every government institution involved in this to speak the same language as the Commission, that the SSMPA violates human rights of Nigerians, and that in addition to our success in court, we need to also begin to record success in policies, success in terms of putting in place actions to check discrimination, to check also and ensure access to social services. We think that the Commission is well placed to do this, but it's not something we can achieve alone. So we continue to work in partnership with organizations in the communities and also other federal government institutions. Thank you very much for this opportunity, and I look forward to further interactions with the participants.
Thank you, Hilary. And again, you emphasize the need to work together, the need to form coalitions and partnerships to ensure that all issues are covered, to educate as much as possible. And I particularly like the point around social and economic rights. I think this is one area where, you know, the impact on livelihoods is pretty high. I mean, there's issues of access to health, issues of poverty, issues of employment, and so on and so forth. And that needs to be streamlined as well into some of this discussion. So the chat is pretty busy, and Jeff has been kind enough to provide some translation. So as one of you is speaking, I would ask just to look through, and I'll try to find some of the questions for you. So going back to Adrian. Adrian, so how, as you plan your litigation strategy, how do you identify a proper forum for litigation? And what are the what kind of winning legal arguments do you also engage? And how can legal practitioners work effectively with activists and other movement actors to identify law reform opportunities? There are some other questions which are basically, you know, you can integrate in your response. What is the social environment like in Uganda right now? And then the other one says, what messages and frames have you found that are most effective in winning people who had earlier supported punitive laws against LGBTI people into moving away from that stance and becoming allies instead of opposition or continue to be homophobic? Adrian.
Yeah, thank you so much, Monica. Thank you so much, Monica. And thank you for those who have raised some questions and concerns, and also for my colleagues who have shared the experiences in the different countries, and also Richard, of course, for our experiences in Uganda. Some good was bring for my academic bit, the book that I wrote on litigation, and how it's built, but also on the practice of what goes on for us in Uganda. So for me, litigation, there are a number of things that you have to put in place before you go to court, and that's very critical, that you don't just rush to court because you're a lawyer who can write down a few things and then go to court. Litigation must be built. You must build the litigation over time, and that's important. So identifying issues is critical. What is the issue that you are taking before the courts of law? What is your concern? What are you asking court to do for you? And if court does for you the thing, what does it mean for you? You know, so you may ask court to do something for you, court does it, but then when court does it, it doesn't actually mean anything for you or your communities. So what's important is, what do you ask court to do? Sometimes there are things like declarations, ask court to make a declaration on the law and the status of the law. That's important. For example, we have cases that have made a declaration on the right to privacy, the right to dignity. And that's important, that everyone is entitled to privacy and dignity as human rights. That has happened in Ugandan courts, and now it's not been a matter of interpretation. Again, the courts have said it, and even LGBT people are entitled to these same rights. That's the issue of the issue. How we choose our cases then is about the issue. What we are doing right now in Uganda is incremental litigation that you build over time to get you somewhere that will be social change happening, happening in Uganda for LGBTI persons. You bring cases before the courts of law in such a way that these cases are going to build up to that end. So that means we are not, yeah, in most cases we are most reactionary. We react to what has happened. Is being proactive, and you don't want to wake up people and be like, you go to court ahead of the government, and before they do something bad, you need to first wait for them to do something, then you go to court. For example, they put in place a law, then you go to court over that law. So reaction litigation, you respond to instances as they come, and then this must fall within your already agreed strategy. We sat in 2012 and agreed on a strategy of things we need to do. Some of the things that we need to get hold of as we move towards social change and also move towards decriminalization of same-sex relations. In terms of avenues, which is another thing that's important, where do you go? Like, what do you go for? With that one we've covered, now we are looking at where do you go? So we have a number of options in Uganda in our legal system. The first court for enforcement, you can enforce a right in the High Court so that the court declares that, you know what so and so has done is a violation of this particular human right. That's the same thing we did with a case I told you about, done on COVID-19 and access to lawyers. The judges declared that, you know what, failing to allow access to lawyers is a violation of the right to fair hearing, and that's damages. Of course, recovery of the damages is a big issue. That's the other thing about litigation, that you may win in court, but your clients actually win, and that's important. That if you win, ever get what they asked for, what they won in court. For example, up to now, we failed to get the money out for people, which was given in 2020, which is unfortunate. But that's because of how the system largely works, that enforcement becomes a problem. So the High Court is for enforcement. The Constitutional Court is for constitutional interpretation. So if your issue, like now, is an act of parliament, then the real avenue to go for is the small cases that just require reaffirmation that this is a violation, although the commission has also become a little bit more complicated of recent. And we also have the international options. We can go to the East African Court of Justice. East African Court of Justice is for the East African community, so countries like Uganda can go there. This is an avenue that you can think about if you need interpretation, more especially around the acts of good governance, rule of law, things that develop these principles that form part of the East African Treaty. And we also have the special UN special mechanisms. So the case concerning detention of the 20 people during COVID-19 was also taken before the UN working group on arbitrary detentions, which essentially in our favor from the UN special from that mechanism. So you have the special mechanisms of the UN, you have the African Commission and the African Court where you can also go. But that is, for me, some of those require you to first exhaust your remedies. Some of them you may not even go, like the African Court, because of the declaration that has to be made. But the issue I'm trying to point out here is the multiplicity of the avenues, and then how you as a lawyer and as the community you have to choose depending on what you want to get for your client. So for me, it's about which kind of avenue creates the most impact for your case or for your people. And also which kind of avenue creates the least negative impact in case you lose, or in case the court makes a decision. For example, before you go to the South African Court of Justice, there's always this thinking, the Court of Justice decision that affects the whole East Africa. It's not just Uganda. You get to the court, a court makes a decision that says, well, laws criminalizing same-sex relations are fine within the context of East Africa. That blocks the way for Kenyans, for Rwandans, for Tanzanians, and that's something you have to be careful before you do, that you have to have litigation in such a way that does not cause effects on people. About the question you asked about community, for me, as a lawyer who is also, I think, part of the movement builders, it's important that the lawyers do not take cases just because they are lawyers. Like I'm going to court because I'm a lawyer. You have to take cases to court working hand in hand with the community. And this is what I talked about before: community consultation, community engagement, community discussions. First, we do that through legal strategy meetings. So we have strategy meetings all the time before we bring cases before court, so that by the time we go to court, we've agreed on a strategy, we've agreed on what to do with our with our communities, and what the communities should expect and anticipate is going to come out of the court processes. So for me, I always think that the affected communities must be at the fore of litigation, even though they may not be lawyers. Lawyers must be at the back supporting the communities to be able to take their matters forward. So for me, that's important. How you identify, how you make sure that the communities join you and are part of you. I think the question on what's happening right now in Uganda, Richard will answer it a little bit better than me at some point, but maybe just briefly in terms of the law, we are seeing an increase in terms of arrests of LGBT people, not arrests rather, in terms of evictions of LGBT people from rented premises. We are having hotels still negotiating spaces, and it's difficult now to hold a meeting. You're not even sure of the security of the event that you're having because of the hotels, and this new thing of the hotels are being told you cannot host people because that would be violating the Administrative Act. And socially, the hostility continues. I think this time around there's more hostility by the general public, of course, arising from what has been said by the Speaker of Parliament and other leaders around the law. So we are seeing much more hostility, even coming in from members of the general public. It has been whipped up over the years, and that makes the operational environment a little bit more complicated. And we also have limited support coming through from elites, for example, lawyers. I belong to lawyers groups, and there's very little support coming in from most of the lawyer groups that we have at the moment, which is problematic because we need allies to be part of it, to be part of the journey, part of the conversations. So we need to do more in terms of building the capacity of LGBT movements to change minds, to change mindsets over the next so many years. Like I said in the beginning, litigation may give you quick wins, but you also have to think of the longer term victories that have come through a sustained campaign. Thank you.
Thank you, Adrian. I like the question that you said, is a win in court a win for everyone? Timing is everything. You know, as you said, there's reaction litigation, which, as it suggests, you're reacting to something that hasn't happened. But a lot about the strategic litigation is about planning. It's about, you know, moving with everyone, ensuring that people support the people that you represent, know exactly what you're doing. But of course, you can't control everything. We know there are rogue lawyers, rogue litigants. We had that happen in Botswana. Fortunately, you know, there was, you know, a way that a coalition that was existing was able to intervene and ensure that the rogue litigation didn't go badly. So it is important indeed. And thank you for sharing your experiences in Uganda. Njeri, the same questions, and basically around the same issues. How do you decide on strategy? How do you decide which issues? How do you decide which course to go to? And in addition, I think there's a question on the Q&A. It says, how would you want the laws to help Africa move forward on LGBTI and human rights in the fight against HIV, considering the cultural, religious, and political diversities characterizing Africa? Go for it.
I think that's a lot of questions. I'll try to do a
there's a lot.
A decent job of, yeah, it is. How do we decide what courts, what issues? So I think the reason why we call it strategic litigation is that we have to head, we're guided by strategy, right? Is that we have to decide what's the point that we're trying to arrive at, and then work backwards, right? Which is kind of the, kind of what we did way back when. I think around 2010, there had been conversations ongoing in the movement about, you know, the state of rights of LGBTIQ folks in Kenya. And there was an exploration of different areas of our lives: education, employment, health, justice, all of these things. And I think the critical barrier, I keep saying that the critical barrier to a chance at equality, a chance at happiness, a chance at fulfillment for people like us consistently showed up as the law, that there existed a law that criminalized the ways that certain people within our community loved each other, and that law was quite widely interpreted to affect any person who was seen or perceived to be LGBTQ or within our community. And therefore, from that law, there was a guarantee of negative interaction with people. So for us, the thing was to then prioritize the removal of this barrier so that there was, so that we could begin to interact on equal ground. And so then the issue then became that we must decriminalize homosexuality in Kenya. If there was ever a chance for people like us to live, just boring, normal, tax-paying lives. We're not asking for a lot. Like, we're not asking for rainbows. I mean, rainbows are nice, and we love the rainbows, but all we wanted was to be existing without the threat of violence, existing without, a constant worry about the intrusion of your privacy, the intrusion of your security of person, the intrusion of your access to education, to healthcare, to all of these things. And so that was a beginning point of the thought around decriminalization of homosexuality in Kenya. And so that fronted several discussions around what are the ways that we can use, what are the avenues that are available for us. And one of the ways we could have chosen to go was to engage Parliament, to ask Parliament to do specific things, including create specific laws or amend laws, particularly at this point, the Penal Code. The thing about working with minorities and belonging in a community, in a minority community, is that you realize quite quickly how, while the law is supposed to be this thing that makes us equal, as a minority, you realize that the law quite often becomes the preserve of the powerful, right? So that an anti-homosexual bill or anti-homosexuality provisions in the Penal Code are not really servicing of all of the people in Kenya, but are a preserve of the powerful. The same way that slavery was a preserve of the powerful and was legal at some point, right? In the same way that interracial marriages, for example, had been legal at some point. So so it becomes belonging in a minority then really narrows avenues that are available for you to create change. And so the way that we ended up at the judiciary was, I think, all of us collectively trusting in this one arm of government. It happened that it had been around a time where Kenya had passed its new constitution. So after the promulgation of the new constitution, I think there was a renewed sense of faith in the institutions, in constitutional institutions, and particularly now we're talking about the judiciary. And we had applied a lot of research in figuring out whether the judiciary had been showing its independence in different matters, even before we ever approached court. I remember at the time that we were going to court in 2013, there had been a case around an organization that was what was called the Mombasa, I think the Mombasa Republican Council or something like that. It had been an organization trying to register itself so that it could do the advocacy work around secession of the coastal region from the whole of Kenya. And they were allowed to register. The judiciary, the High Court, at that point gave a decision that said that they should be allowed to register like any other. Around the same time, we had the Atheist Society in Kenya that had been trying to register. They also had been had gotten a court judgment with the court saying that you might be unpopular, but you're within your rights to want to register an association as atheists, right? That your objectives are nothing illegal, they're just unpopular. But you know, there's a brilliant judgment, our first judgment by Justice Lenaola. He says something something around popular morality cannot be used as the base within which we deny minorities of their rights, which is something that is so fundamental in a democracy. So that's kind of how we end up at the judiciary. And the reason why we begin even with a registration case, outside of the fact that it was necessary for us to be registered as an NGO, so we could engage and we could carry out our objectives, it was also necessary to see the reaction of a judiciary on adjudicating matters that were wildly unpopular at that time, but then also around a very legal arguments on and specifically on a very small thing. This registration case, it was very linear what we were asking the court. Particularly, we were asking for an order of mandamus, like we're asking for the court to ask the NGO board to register us. And in 2015, when we first received that decision, it was a confirmation to us of what we already believed, that we should have had faith in our judiciary, that outside of all of the pressures by the executive, by the parliament, by the public, that the judiciary was standing firm in its own belief, in its own conscience. So that's part of the reason why we ended up doing this litigation. The other thing about strategic litigation, as I wrap up, is that there's cases that we plan for. There's cases that we take time and we go through research and we talk to potential petitioners and finally we end up in court. But then there are cases that happen and you end up filing because it is a thing that you must do. And with our anal testing case, that's exactly what happened, that 2 people had been randomly arrested somewhere in the coast of Kenya and had been forced to undergo a really horrific test. And we had to quickly run to court to apply for a stay of prosecution first, but then also to file a case to ask about the constitutionality of this practice. So while it was a strategic litigation case, it wasn't a case that we'd sat and thought about and prepared for, So we had to prepare on the go. We had to get the right lawyer on the go. We had to get the right instruments, the right case law, all of the things as we went by, right? And I think the good thing is that at that point, we'd already been affirmed by the judiciary already, and we had faith in the ability of the judiciary to determine these matters fairly. Yeah.
Thank you, Njeri. I think you have raised a lot the same issues as Adrian, but you've also added the idea to engage other decision makers, such as parliamentarians, to amend laws and basically remind them of their responsibility to protect as representatives of people. As well, I think you talked about the approach in litigation, which is that it should be incremental, and how you started out with that case not by accident, but because you needed to explore, the appetite of the court to actually be willing to hear these cases and with an open mind and apply themselves using all the tools that are available to come to the right decision. And I think that is that incremental approach, which Uganda and a few others have already engaged, has actually borne a lot of fruit. Richard, we come to you next. So we know that there are many different people, many different LGBTI and key population organizations working with this, and there are many big personalities within this movement. So how were the strategic and tactical and personality differences among LGBTI activists managed and how did it work? This is from 2014 to the date. And then we also know that, the coalition is not just of LGBTI persons, and you want to move across the human rights spectrum, as well as across the region and regionally and internationally. So what are the most important roles for actors from beyond the movement, and whether it's academics or feminist allies or international organizations? What roles can they play, and how do you manage that kind of interest and intervention?
Okay. Thanks so much, Monica, for the question. And again, thanks my colleagues, Adrian, Jerry, and Hilary, for your earlier interventions. So one of the things that that we have learned over time is we can never agree, all of us, on a specific something, but I think what's important is to having a common goal. And this work is not about individuals. It's about the community. It's about ensuring safety and security. It's about protection. And it's about creating an environment that is enabling. And the moment you have that understanding, it's one thing that has kept us going. The other aspect is that over time, community organizations, allies and partner organizations have grown. And each of those different organizations and entities have their niche. And I think that's also another thing that's important, that when we are working in a coalition, it's what you bring on the table. What are you an expert in? And it's that understanding that has helped us really evolve over time, that even if you draw people from the academia, from the legal, and again, like Adrian had mentioned, when you're litigating, it's just not because you're a lawyer and you understand the law, but it's about what does the community want? And that kind of understanding has helped us to have the different sectors or the different individuals come on board, because we've in a way aligned our work. And when we are working together as a collective, each of us brings their expertise on board. And this is why, for example, putting together the legal case and the petition, it had different individuals. It has people from the academia, politics, people from the legal fraternity, community members. And this can also be clearly seen in the two petitions that as CFE or Convening for Equality are supporting. These are characterized by a cross-section of people who are brought from different sectors, but ensuring that there is a balance. So just to also really sum this up, to say that there's always, there may be misunderstandings or there may be this or that, but one thing we have learned is that the bigger picture is the community, and this work is way too much for us to be colliding on one small aspect. And this is why we have this convening, to ensure that each of us brings the expertise, they bring what they're better at, to the collective. And this has helped us to deal away with personalities, because again, it's not just about you as an individual or individuals because you're leaders, but rather it's about working for the betterment of the community, but also really understanding when does so-and-so, or when we come in. It is something that has also helped us, because then we don't have a moment of collusion or having competing agendas. We have a common agenda, which is now we are fighting the law, and all our strength is to ensure that that's done. But also we need to protect the community. So we have the rapid response teams really ensuring that that is also going on. Different aspects of media and all, and really creating a wide net of responsibilities is something that has also really helped us, because there is no single point whereby people feel like they have nothing to do or contribute to the cause. And I think that's really also important to always identify those different sectors that different individuals, different partners, different organizations can really contribute depending on their niche, because that's the way that people can also feel attached to the processes and also engage in the processes. Thanks.
Thank you, Richard. I think we all appreciate, the being able to find that common goal, the bigger picture. And I think assigning everyone a responsibility also make sure that people own this strategy. They own their own future, so to speak. And I think that's a lesson that can be learned across. Hilary, I think you've also talked about this kind of coalition and working with others. And so I want to ask you, who have you been able to bring along on these issues in your country through your work, and what plans do you have moving forward? And then also, if you can address yourself, how do we use different networks in Africa? This is, NHRIs, human rights mechanisms, et cetera, to support each other within the region.
Thank you very much, Monica. And I want to also thank my colleagues who have responded excellently to the questions, and also participants who have really asked some quite incisive questions. In terms of our work in Nigeria, prior to now, of course, the Human Rights Commission not only existed, but in terms of its powers and mechanisms, the act was amended in 2020 that actually made the commission a Class A national human rights institution. So you also need to look at it from an institutional context, where you have a commission that is almost 99.9% independent from the government. You are able to do quite a lot of things, unlike what you have in some other countries. But in terms of our work and coalescing together, I think what we have done is that people have welcomed the idea of a national human rights institution working in tandem with other partners to protect the rights of people in the community. So we've been able to also put together available resources in terms of institutions and their other mandates from the United Nations country team in Nigeria, as well as also working with other bilateral partners, the Americans and their institutions, including USAID, PEPFAR, and also, but most importantly, our National AIDS Commission, the National Commission on HIV and AIDS in Nigeria, has also become a key partner of the Commission in terms of looking at integrating human rights into protecting, into the protection mandate of the AIDS Commission, but also integrating human rights into the national HIV and AIDS response in terms of protection of the rights of key population. Someone mentioned how can we ensure that the discrimination faced by people in the community does not impact on their access to HIV services. And I really think that that's one of the key areas the Commission is working on, in addition to other partners. Where we need to do more as a Commission is in our work with people within the community, especially community leaders and community associations that provide other services to members of the community. We are in a very big country, and you need to stretch your reach out very wide for you to be able to go to the nooks and crannies of Nigeria. We are currently working with at least 7 partners within the community who are big organizations in their own rights, but also have a lot of work at state and local government level. You talked about what can we do in the context of the national human rights institutions? And I just want to say that our umbrella body in Africa, which is NANRI, has for the past 2 years now been implementing a program on SOGI's rights, which is sexual orientation, gender expression, identity and expression rights. And this project was built upon the resolution of the African Commission on Human and People's Rights, upholding the rights of sexual minorities in Africa. And that is a very big entry point. But what I have seen from our work with NANRI is that not every organization within the community engage with their national human rights institution. I know that most countries, the national human rights institution is heavily integrated into government. So most people are not even comfortable dealing with the NHRIs. We are trying to see how we can support the NHRI in Uganda to respond to the human rights violations and other issues that are arising from the enactment of these obnoxious laws. And we hope that at the level of NANRI, that we can engage more with civil society organizations working also in this area. Then there is also in West Africa currently, and they are meeting in Banjul as I speak. And one of the item on the agenda is the situation of human rights in Uganda as well. So there is a network of NHRIs in West Africa as well that are just concluding their meeting in Banjul. So these are some pieces of institutions, but mostly networks that can amplify the voices of what people are doing at the national level. Since we already have a regional instrument, which is the resolution of the African Commission on Human and People's Rights, which is the mechanism of the African Charter on Human and People's Rights that has been acceded to and even at some point domesticated by most of our countries. I think that this is an entry point. Andrian made mention of the East African Court. In West Africa, we have the ECOWAS Court, which was basically set up as a court on economic and trade issues. But right now, 80% of its docket is on human rights. And I think this is one of the key entry points that we can also adopt. But we cannot achieve a lot working in silos. We need to continue to reach out across borders to see how we can work together to respond to some of these emerging issues. I saw a comment from one of the participants from, is it Benin Republic or Togo? At the moment, they don't have restrictive laws, prohibitive laws on same-sex marriage. But the truth is that African nations copy each other. And when politicians are losing elections, when politicians are losing in citizens' polls, the first thing they go for is to appeal to religion. They appeal to morality, so-called morality. And that is where you see these laws begin to be passed. We saw that in Nigeria in 2014. We were seeing that in Ghana. It's already happening in Uganda. It's happening in Namibia. So I think there is a pattern to this, and the only way we can succeed is not in leaving our comrades in those countries to work alone, but also to amplify their voices. This is worse than military coups. So if we can all speak together when there is a military coup in one country, I don't see why we cannot amplify our voices when human rights, the right to human dignity is inviolable. It is also not derogable. In all our constitution, the right to dignity is not derogable. You know, you cannot pass a law derogating on the right to dignity. And I would just want to stop here. Thank you very much.
Thank you, Hilary, for raising some of these things. NANRI, it stands for the Network of African National Human Rights Institutions. So it's an important regional network that we can work with. Of course, the African Commission, especially Resolution 275, which, as he says, has been implemented in other countries. I'm going to give our speakers 1 minute each. And if you can try as much as possible to give some kind of recommendations. Some of the questions are about what can be done. How can we support the work that is going on? How can we address the issues around customs and traditions? What educational materials, what education can be conducted? So, Adrian, your last words. 1 minute.
Thank you so much, Monica. Maybe what I want to say in terms of summarizing is that this is not just a Ugandan problem. It's not just a Kenyan problem. It's not just a Nigerian problem. It's an African problem generally. But also, I'm here in the US, and it seems to also be a US problem. There are all sorts of laws that are coming up against trans people, against more than 4,000 bills in different parliaments in the US. I'm like, all right, okay, what's going on? So this seems to be a worldwide problem. And if we take it like this, then we can be able to craft solutions that work worldwide, that work across Africa, that work across board. So all of us need to support each other. We need to work together, not just working together in a country, but also working together across countries. The Kenyans and the Ugandans should be speaking, the Ghanaians should be speaking, the South Africans should be speaking, even though they may be well right now, but still things may turn the other way, like we are seeing in different countries. So for me, what I'm calling for is let us have a continent-wide or even a worldwide sort of campaign where we all relate to each other, where we all understand each other's pain, where we can all work together to ensure that these laws are basically, we get rid of them, but also to ensure actual protection for LGBTI people in the different countries. Thank you.
Thank you for that brief response. Jerry, can you also give us a 1 minute response, please?
Yeah, I think for me, it's important that we don't stop speaking up. I feel like there's been we've done a lot of work as LGBTQ activists over the years to form allyships, to rally people along, and when there's been this massive kind of backlash, I think people have started to cower and started to feel under pressure. I think this is, if anyone has counted themselves as allies, if anyone has counted themselves as a good person or as wanting for good to exist in this world, this is not the time to cower or to roll back or to be quiet. This is the time to speak up, and not just to speak up in the ways that we know, but to speak up consistently in consultation with the affected communities. So keep checking in. I think everyone in this world has their own sphere of influence. And if however many of us that are on this call at this point today made a point to speak up within the spheres of influence, we definitely would see the effects of that, the positive effects of that. Yeah, so that's all I'd add.
Thank you, Jerry, for that. Richard, any last recommendations and conclusions?
Yeah, no, thank you so much, Monica. This, I think there's need for us working together across movements, because what's happening now, there is a high increase in anti-gender movements that are targeting women's rights, that are targeting SRHR, that are targeting LGBT. And the moment we understand that this is just not our only issue or their issue, it will be important, then we will be working together, because if you look what's happening across the region, these people, when they talk about abortion, the next is homosexuality. If it's homosexuality, then it's abortion or women's rights. And I think it's really important for us to start working across movements. Secondly, I think as Africa, it's high time we started doing soul searching, because there is this whole ideal that people think being African, being pro-African, being pro your country, you must be anti-LGBT. And I think we need to start dealing with that situation, because if you look at all the discussions about our African values or our sovereignty as independent countries, I think we need to have that honest conversation right now, because being LGBT is not an issue of you're not African, not LGBT people are Africans like any other African. And I think we need to start claiming our Africanness, and we cannot allow states or politicians pushing us on the side because they want to fulfill their populist kind of agenda. And I think this also has opened ways where we have people like from Family Watch International coming and dictating or teaching us about African values. Like, excuse me, how can a white lady from the US come to teach us Africans, African values? And we are here embracing and seeing our governments giving rolling red carpets for such individuals. So I think we really need to do really that soul searching and have this conversation honestly. And lastly, I think as we're dealing with all these policies and what, we need to start investing in communities so that we move away from only just focusing on issues of human rights, but we need to look at an LGBT person in their entirety. We need to talk about economy, we need to talk about education, employment and all, because all these are things that we are always excluded, and we are rather focusing on just one piece. So thank you so much, and I really appreciate the time that I've shared with all of you.
Thank you, Richard. Hilary, your last words, please.
Thank you very much, Monica. I just would want to end on the note that based on my experience, what we are facing is not just same-sex marriage, not for people to live their lives as they want it to be. What we are facing torture, inhuman and degrading treatment by the police. We are facing discrimination of citizens in their own countries in terms of access to services, access to education, access to life-saving drugs. What we are facing is abrogation of the right to freedom of expression and freedom of movement, and also a freedom to peaceful assembly. What we are facing is the right to freedom of life. So when we begin to look at all of this, and not whether Hillary decides to marry a man, you know, or whether I decide to transform from one gender to the other, I think we will be missing the point unless we come to this unmistakable realization. And I speak the language of human rights, and that is why I also want everyone who is engaged in this struggle to continue to push forward human rights. That is what belongs to everybody. If armed robbers, terrorists can be treated this humanely and equally, how much more people who just decide to live their lives as they have decided to, because it is their fundamental right. And I think this is the best human rights approach that we can adopt, to look at all of this from the universal human rights, their interdependence, and also how human beings created by God would continue to enjoy these rights. I thank you very much.
Thank you. What a way to end. Human rights are fundamental. They're universal. They're inviolable. And everyone is entitled by the mere fact that they are human beings, regardless of any difference. So I want to thank my very able speakers, and I want to thank you for being here today and sharing your knowledge and your experience. And I also want to thank you for all the work that you're doing in your countries, bringing together these strategies that you have described, and working through this to bring some kind of comfort and safety to a very marginalized community of people, often risking your own lives, your own welfare and wellness and health. And I want to, take this opportunity to really thank you on behalf of UNDP and my colleagues, and on my own behalf, and wish you a very, very good weekend. I also want to thank people who have stayed on. We've run over time, stayed on and interacted and asked the questions, shared their own experiences through the Q&A and in the chat. And hope that this has brought you some kind of learnings and lessons that you can use in your own countries. And someday, we will meet and share some more. In the meantime, I say good luck and all the best. See you around. Bye.
Bye-bye.
Bye,
Thank
everyone.
you.
Bye.